Resuming debate, the reprise de débat, the honourable member for Halifax.
Thank you, Mr. Speaker. I'm proud to have shared my time with the member from Churchill and was so pleased to be here in the House when she brought the voices of Aboriginal leaders to this House of Commons, their voices speaking out against this bill. As she pointed out, we are the only recognized party in the House that is opposing this bill, and we should oppose it with everything we have, because this is a terrible bill, Mr. Speaker. I'll pick up on that piece about unlawful. That's actually going to be the crux of my remarks today, very much with the lens of how this applies to Aboriginal groups and how this applies to environmental groups. And a lot hinges on that word unlawful, because if we're looking at activity that may undermine the security of Canada and there's an exclusion for unlawful activity, well, unlawful doesn't just mean the Criminal Code of Canada. Unlawful could mean municipal permits. Unlawful could mean a strike, a wildcat strike. So this is really dangerous legislation to think that if there's a wildcat strike or an Occupy movement, an occupation of town property, the camps that we saw set up, those could potentially, under the eyes of CSIS or this government, undermine the security of Canada because they don't have the right municipal permit. All of a sudden they're scooped up in this anti-terrorism legislation. So that's really the crux of my argument here today, Mr. Speaker. This is a big bill. It does require thoughtful analysis, and I've been reading through some of the analysis that's been done. These aren't just words on the back of a napkin, we hope. Each word matters. Every single word here matters, and we really do need to look at this word unlawful and the implications for environmental groups and Aboriginal groups. There's one particular piece of writing by Craig Forsese, an associate professor of law at University of Ottawa, and he has written a book on national security law, and he maintains a blog where he posts updates because, as you know, our security law is ever-changing, especially with this government. And so he posts responses as the law is evolving, and he has posted a very thorough analysis of C-51 and the issue of unlawful. And the post in particular I was reading was called Bill C-51, Does It Reach Protest and Civil Disobedience? And he does look specifically at will this bill allow the government to target protest and advocacy groups. So he points out that there's nothing in the bill that brands democratic protest movements as terrorist. So you can't reasonably make that assertion. But there's a lot in this bill that could wrap up democratic protest movements into the orbit of security concerns. He writes that, quote, under C-51, the government will be able to share internally and potentially externally a lot more information about things that, quote, undermine the security of Canada, end quote, that concept is extremely broadly defined, more broadly than any other national security concept in Canadian law. Yes, it can reach the subject matter of many democratic protest movements. So that's the end of the quote from Professor Forsese. But he talks about this exclusion. The concept of undermining the security of Canada does not apply to lawful advocacy, protest, or artistic expression. And this, like I said, this exclusion for lawful activity is really important. And we can understand this exclusion a little bit better when we look at our legislative history on anti-terrorism legislation, and we look at previous anti-terrorism pieces of legislation. Because lawful or unlawful, it means you must be fully compliant with the law. And as I said earlier, we're not talking about simply compliance with criminal law. We're talking about full compliance with municipal and regulatory rules, labor laws, including in relation to strike and protest. So Professor Forsese continues. He writes, I'm not making this up. This is exactly the same debate we had in 2001 with the Anti-Terrorism Act. That act introduced a definition of terrorist activity. For one aspect of that definition, serious interference with an essential service, there was an exclusion for lawful protest, and concern was expressed widely that this reference to lawful meant that wildcat strikes or protests without permits that could implicate essential services might be branded a terrorist activity. And so the government dropped lawful as the precondition to protests. That's the end of Forsese's quote. That's important. The government actually took out the word lawful because of this concern. It might sound strange on its face because you might think, well, of course, things should be lawful. But again, we go back to even just, labor laws, and we go back to municipal laws here. It doesn't have to be criminal law. With the old Anti-Terrorism Act that was in 2001, the word lawful was dropped because there's no real prospect that democratic protest movements are terrorist activity. So you can argue that the lawfulness distinction isn't useful when you're looking at terrorist activity. But what about when you're looking at actions that potentially undermine the security of Canada? I'm going to continue with something Professor Forsese wrote. Quote, violating regulatory or municipal rules is bad. People should be fined, possibly prosecuted. That's why we have police and open, transparent courts with due process and appeal rights. But the question before Parliament now is whether peaceful democratic protest movements should be a security issue handled covertly when, for example, they don't have the right municipal permits for their protests. And specifically, should such a movement fall within the ambit of the new undermine definition or the expanded CSIS powers under the existing threat definition? Given the experience in 2001 and the legal views expressed by the government of the day, we have to conclude that if the government continues to include the qualifier lawful in its exceptions, it does so with its eyes wide open. It really does mean to include illegal strikes. Am I okay for time, Mr. Speaker? Thank you. It really does mean to include, for example, illegal strikes that take as part of its form a demonstration in the streets. And this is an example that's been used by some in the trade union movement within the undermine the security of Canada concept in the information sharing rules. And it also means that this government is comfortable with the idea that if other elements of the threat definition are met, democratic protest movements with tactics that do not square in every way with even municipal law may properly be the subject of CSIS investigation and possibly even disruption. This is Professor Forsese saying I take no view on whether CSIS would ever have the resources or the complete lack of internal governance, checks and balances to actually proceed in this manner. That's not my point. My point is this. When we craft national security law, we craft it to deter bad judgment. We do not craft it to be so sweeping and ambiguous that it must depend for its proper exercise in a democracy on perfect government judgment. Very few governments are perfect. And even if you think this one is, what about the next one? Well, what about the next government? That's the end of his quote. What about the next government? More importantly, I do think, what about this one? You know, Mr. Speaker, I read an article by journalist Sean McCarthy in the Globe and Mail, and he was talking about the potential for this law to be used against legitimate peaceful dissenters like Aboriginal groups and environmental groups. Now, he quoted a public safety spokeswoman who said Bill C-51 doesn't change the definition of what constitutes a threat to Canadian security, and added that CSIS does not investigate lawful dissent. CSIS does not investigate lawful dissent. Well, then why is it that we know, through access to information requests obtained by Greenpeace, that the RCMP has characterized environmental groups as the anti-petroleum movement, that the RCMP has labeled this movement as a growing and a violent threat to Canada's security? They identify highly organized and well-financed anti-petroleum movement that consists of peaceful activists, militants, and violent extremists who are opposed to society's reliance on fossil fuels. And then we go back to the overarching purpose of this bill, and that is to turn our security investigations, our security intelligence agency, essentially into a law enforcement body. We are taking the powers of the RCMP and giving it to our intelligence security agency. That's not why it was created. And if we think that the government of this day has the good judgment not to exercise or abuse this power, then we are sorely, sorely mistaken.
Hear, hear.
Questions and comments? Question commentaire. The Honourable Parliamentary Secretary to the Minister of Public Safety and National Security.
Thank you, Mr. Speaker. I'd like to thank my honourable colleague for that speech, but I would like to, in fact, correct a couple of things. There has been I'm not sure whether they were able to read through the entire bill. I know that the leader of the opposition was referring to issues concerning groups that maybe, have dissent against the government or issues with protesting and so forth. That's actually factually incorrect. Nowhere in this bill, and in fact, in this bill, it's very clear. It's very clear. It's right on page 3. There's been some confusion between the CSIS amendments and amendments made to information sharing, but right on page 3 with regards to information sharing, it states, for greater certainty, it does not include lawful advocacy, protest, dissent, and artistic expression. And when it comes to CSIS and the activities that CSIS can investigate, that definition of what constitutes a threat to national security is actually in the CSIS Act itself. So it's not in the amendments that the honourable member might be referring to. And so I guess the question, I've asked this before, I would like to know exactly where in this bill does that member think that we are targeting people who may protest, may have dissent, because clearly it's indicated that that's not the case. The bill targets terrorism and...
Order. Please. We're asking questions are to be kept to 1 minute if at all possible. The honourable member for Halifax.
Well, Mr. Speaker, I just stood here and gave a 10-minute speech about... That was the answer to that question. My entire 10 minutes was about the word unlawful and that exclusion, drawing upon the records of the debate from 2001 when we debated this in the House of Commons under the Anti-Terrorism Act. It's like the question comes after the answer. Had she listened and not just been reading from talking points, my entire 10 minutes answered that question. Thank you, Mr. Speaker.
Questions and comments? The honourable member for, York West.
Yes, I think to my colleague, you spoke extremely well, and you certainly enunciated an area that I am very concerned about when you come to the issue of lawful demonstrations. I have been part of and viewed hundreds, if not thousands, of demonstrations on a variety of issues. And did they have permits to do that? No. So that would mean that they would then be unlawful under the current way, which is why we very much in our amendments want the word lawful restricted and taken out of there. But does the member not recognize that there are some good things in this bill? The changes to the no-fly list, the building on the powers of preventative arrest. There are issues. We continue to have some significant issues with this bill, and we're hoping to change that with our amendments. But does the member not see any of the positives that are in this bill when it comes to protecting Canadians?
Member for Halifax.
Thank you, Mr. Speaker, and I appreciate the question, and that's a fair question. But my answer is no. I actually don't see any of the benefits of this bill because it's not actually a choice between our security. Oh, was that me? Sorry. It's not a choice between our security and our rights. It's not a choice. I don't think that is me. Okay. I don't think that there is I think that's a false choice. I think the two are married hand in hand. And when I look at the fact that CSIS was created out of problems with the RCMP engaged in intelligence gathering, CSIS was pulled out, that intelligence gathering function was pulled out specifically so that RCMP could be law enforcement, CSIS is intelligence gathering. And now we have the crossover effect happening backwards, where CSIS is actually getting powers that really do liken it to a law enforcement body, and I don't think that's appropriate in the least, Mr. Speaker.